Hello and welcome to a special episode of the Just Security Podcast. Presidents have long pursued policy prerogatives through the Department of Justice, but traditionally, there's been a clear division between those and the Justice Department's enforcement decisions. On March 5th, 2025, the NYU Law Forum and the Reiss Center on Law and Security at NYU School of Law co-hosted an all-star panel of experts who have served in senior positions at the White House and at the Department of Justice to assess the degree to which the division between the President and the Justice Department has now changed. Among the topics they discussed are what is the origin and reason for the Justice Department's measure of independence? How has this independence worked, given the department's mix of political and career employees? And how is the current administration observing those lines? The expert panel consisted of Vanita Gupta, a distinguished scholar in residence at NYU School of Law and the former Associate Attorney General of the United States; Lisa Monaco, a distinguished scholar in residence at the Reiss Center on Law and Security and the former Deputy Attorney General of the United States; and Breon Peace, the former United States Attorney for the Eastern District of New York. Trevor Morrison, a former Associate White House Counsel, the Dean Emeritus, and Eric M. and Lori B. Roth Professor of Law and Faculty Co-Director of the Reiss Center on Law and Security, moderated the discussion.
Okay, good afternoon, and welcome to this week's edition of the NYU Law Forum, which is co-hosted this week by the Reiss Center on Law and Security here at the law school. We're glad you all could join us, both in person and those watching online. Our topic, the Department of Justice then and now. I was thinking of starting with a joke that it's good that we're having the panel today while there still is a main justice building. There was a reporting yesterday that the government was intending to put that up for sale. Apparently, main justice has been removed from the for sale list for now. But there's something just in that story that encapsulates perhaps the magnitude of the changes in what's going on in the department. Between the department as we all knew it in times that we served there and the department as it is today. We have a fantastic panel, and I won't give any of them the lengthy introductions that they deserve because that would take all of our time. But very thrilled to have with us Vanita Gupta, class of 2001 here at the law school, who is now a distinguished scholar in residence here at NYU Law, served most recently as Associate Attorney General in the Justice Department during the Biden administration, and has served in important positions in the department at earlier points in her career as well. Breon Peace, class of 1996 here at NYU Law, who served most recently as the United States Attorney for the Eastern District of New York, has a long career as well in both the private sector and in government. And Lisa Monaco, most recently the Deputy Attorney General, the number 2. So we have the number 2 and number 3 positions in the Justice Department during the Biden administration. And Lisa now is back at the law school as well as a distinguished scholar in residence and affiliated with the Reiss Center, among other things. These are absolutely the best people that we could bring together, that anyone could bring together to talk about the department, its traditions, and changes that seem to be afoot at the department. I do want to emphasize that although all 3 of these folks served in politically appointed positions in the Biden administration, it was not our design to represent only former Biden administration officials here. We actually reached out to a number of folks who served in appointed positions during Republican administrations, and our panelists have served in government during Republican administrations as well. All the folks we reached out to were going to the same white-collar criminal defense lawyers conference down in South Florida. So there you have it. So we have a number of topics to cover today, and why don't we just dive right in. Oh, I'm Trevor Morrison. I teach here at the law school. Glad to be with you. So every new presidential administration comes into office with its own policy agenda, and it's not unusual for that policy agenda to include elements for the Justice Department within its areas of responsibility. And so any new White House would expect the Justice Department to help implement its policies to the extent that they bear on the department's work. At the same time, there have traditionally been certain norms structuring the relationship between the White House and the department, especially when it comes to enforcement decisions and enforcement actions. I thought maybe we might start there to say a little bit about what the traditional line is in terms of how we think about the relationship between the White House and the department, what the origins of that are and what the reasons are for it, and how, if at all, it's changing under the new administration. Lisa, do you want to start us off there?
Sure, happy to. Can folks hear me? Is this on? Great. Well, first, it's great to be back at NYU. You'll notice that I did not attend NYU Law School, class of 2001, class of 96. Yeah. I went to another law school, go University of Chicago.
Nobody's perfect.
But it is great to be back and also to be here with my former colleagues and my friends, and former dean, Trevor, of course, notably left off his own introduction. It's great to be back with Dean Morrison. So let me start a little bit kind of going back, give a little history about the norms and traditions that have traditionally structured, and I use that word advisedly, and I'll come back to that in a minute. But I'm kind of fond of describing this relationship or the unique role that the Justice Department has long held as wearing two hats. It's really unique, I think, and I suspect my panelists, co-panelists would agree with me. It's really unique in our government, and certainly in the executive branch, for wearing two hats. And what do I mean by that? It is and has long been, a independent investigator and prosecutor. Of course, the Justice Department has 5 different law enforcement agencies that are within it, and of course performs prosecutorial functions by assistant U.S. attorneys and trial attorneys throughout the Justice Department. So one hat is this independent prosecutor and investigator function. The other hat is as a entity within the executive branch headed by a politically appointed attorney general and other political appointees, of course, appointed by the president. It is bound to and responsible to fulfill the lawful priorities and carry out the lawful priorities of the president, any president. So those are the two hats. And so what does that mean in practice? The way I think about it is any president can set and does set appropriately the policy priorities of his, not yet her, administration. So for the Justice Department, that could mean, okay, the president says healthcare fraud. Going after healthcare fraud is going to be our #1 priority when it comes to criminal enforcement. Great. Then the Justice Department is responsible to the president and his priorities and should align its resources and initiatives to fulfill that policy priority. What it doesn't mean, though, and has long across administrations of every party, it doesn't mean that the president or anyone in the White House or any other political appointee can direct or involve themselves in a particular prosecution. I want you to go after that healthcare CEO, that hospital system. Okay? So those are the dual hat that I often describe it as. So where does this come from? It really originates in the structure. I said I was going to describe the structure. The history here really arises out of Watergate. Amongst a number of different issues that arose during that time in the early 70s, the then serving Attorney General found himself indicted, prosecuted, and serving a prison term for obstruction and perjury for crimes committed during Watergate, to include being involved in the planning of the break-in of Democratic headquarters. That, understandably, amongst a number of other issues, reduced confidence in the Justice Department that it was actually carrying out its investigative and prosecutorial function in a way that was devoid of partisan taint or improper political or other influence. So after Watergate, there was agreement, and there has now, since that time, going back decades, in the main, agreement that the Justice Department should serve that dual-hatted function. And there have arisen norms and policies and procedures to enforce that or to structure that relationship, that separation. The White House can set policy and does set policy, but stays out of the individual enforcement decisions and investigations. And that has been structured with things like a policy set by Justice Department and White House leadership going back decades to say, here's how we're going to govern our discussions on any of these matters. It's called the White House contacts policies. The Attorney General has set Attorney General guidelines. Here's how we will conduct investigations and what type of factual basis we need to make sure we have before we unleash the incredible power of the nation's premier law enforcement investigative agency, namely the FBI. So those policies, those structures have really governed that separation, that dual-hatted relationship now for decades. And as I said, in the main, have been respected and adhered to, and there has been agreement across administrations for decades that that separation should occur. And what we are seeing now is a dissolution of that agreement, I think, and we'll talk about it more, where we're seeing some of that structure still in place, where it's being observed and where it's not being observed.
Do you want to?
Yeah, just to put even a finer point on what Lisa has been talking about, we spent a lot of time at DOJ leadership policing that line between the White House and the Justice Department. And for any of you who know the kind of the way in which the relationship is structured, the White House policy folks are not supposed to speak directly to Justice Department employees without the buffer of White House counsel's office. And it is exactly to meet the goals of what Lisa is talking about, which is to prevent improper interference where policy and enforcement can kind of run into each other. And I'll just use an example. I mean, Lisa, when she was Deputy Attorney General, really made it so that there were 6 of us in the entire building of the Justice Department who could engage with counsel's office at a senior level on matters that were going to be new or discussing affirmative enforcement. Or any type of enforcement. And part of that was we needed to be able to mind that relationship and those set of relationships. And we were also coming off of a prior administration where there was a lot of concern about the blurring of those lines already. And so when we had to police them, and it wasn't always easy. When the Dobbs decision came down and the Attorney General said, we're going to set up a reproductive rights task force, and it's going to involve 12 components of the department, and we're going to figure out where we can, every lever we have to protect reproductive rights. And the White House had a lot of feelings about where we should be filing and where we shouldn't be filing, or how much we should be filing, et cetera, et cetera. And we, the DOJ leadership, had to insulate the career staff from all of the wishes of the White House to be able to take those in, but then also to filter it and allow for career staff to make decisions, to do the investigations and make prosecutorial recommendations, whether they were in the criminal context or in the civil litigation affirmative context. And it was very intense work, and there were a lot of feelings around all of this, but the policing of that line has been something that has been core since Watergate to the relationship between the department and the White House. And I think there are several examples, and I'm sure we will talk about, but the notion that criminal enforcement authority, this is especially important with criminal enforcement authority, where the justice manual that exists and kind of polices prosecutorial decision-making at the department, the whole authority, the justice manual is written so that criminal enforcement authority cannot be used to pursue political enemies or political aims. And so when you have a candidate who's literally campaigned on a retribution agenda and talked about the function of the Justice Department in a very different way that blurs those lines, that we will have those discussions about how this is manifest, but this is obviously a quite stark diversion, even in terms of goal setting.
Trevor, can I just
Please,
want to say one thing? When you think about the Department of Justice, we talk about this all the time, you have a mission, right? A mission is to do justice, to pursue equal justice under the law. The norms that my colleagues spoke about are designed to insulate those of us who are in positions to make those decisions about who to prosecute, what crimes to enforce, et cetera, without improper influence, as Lisa mentioned. But it's also an element I think is important to remind everyone about how the public views the Department of Justice. These norms are also designed to instill public confidence in the body that is administering justice around the country, to build and maintain public trust. And if the public believes that the decisions being made by people in our seats and people around the country are driven by political influence or racial animus or personal interest with respect to wealth or other issues, you lose all confidence in the system, and people will not be satisfied that we are in fact pursuing the mission. So I wanted to mention that because public confidence to me is a critical element of why you have norms, why you follow them through administrations, and why you try to maintain independence for the people who are making these very important, life-changing decisions.
Just speaking about the norm of limiting contacts between the White House and justice that we've been referencing here, it's limited, but there are channels for contact between the White House and main justice. But I would say, would you all agree that the norm of very limited contact is even greater when we're talking about direct communications between the White House and, say, a particular U.S. Attorney's office,
Absolutely.
where the need, in part, to ensure that there's public confidence in the way the job is being done, the norm is one of even greater separation or even more limited contact. Is that fair?
Absolutely. And if I had heard of a person in the White House, I don't care, low level to high level, had reached in and called somebody in a U.S. Attorney's office, a prosecutor, I mean, I would pick up the phone and call the White House counsel immediately. It did not happen, but if that had happened, that would be, in my view, a very, very dangerous overstepping of that norms. And we keep referencing norms. I mean, just to be very, very clear, this is entirely norm, practice, policy-based. There is no legal prohibition on the president picking up the phone and calling the attorney general, the deputy attorney general, about a particular criminal investigation. You have had presidents of both parties and their White House counsel and their attorneys general say across the, across the years that would be a very bad idea and very bad practice. But there is no legal prohibition. So I do think it's really important to underscore that. So the norms that we're talking about, the policies, the guidance that we have put in place and past administrations have put in place really are to structure those relationships. And Vanita mentioned a very small number, a handful of people. It's not that those conversations can't ever happen, but the idea is you want a very clear channel. The Attorney General and the White House counsel, or the Deputy Attorney General and the White House counsel will decide, okay, on this issue, this litigation, it is only going to be discussed between person A and person B. So you make sure that it is not, that the kind of habits don't get loose.
More broadly, what are some of the ways that the department, and it's early days, obviously, but what are some of the ways that the department is being run differently, is operating differently, either in terms of how it's structured, how matters are being staffed, or even substantive priorities that are being pursued now compared to previously? Vanita, do you want to start, or anyone who wants to jump in?
It's hard to know where to start.
Yeah.
Do you want to?
Well, I mean, I'll start with what seems to be at least some surface continuity. This may be a little bit surprising, but several weeks ago there were reports that the White House counsel, David Warrington, issued a White House contacts memo. This is in keeping with prior White House counsels and prior attorneys general, each issuing their memos to their staff saying, here's how we're going to pursue the structure that Vanita and I and Breon have talked about. So the White House counsel, David Warrington, has reportedly issued such a memo, and according to public reports, it has many of the same features that we have described here. It differs, I think, in some respects, again, according to public reporting. For instance, it says that the president and the vice president and the White House counsel, it is explicit. It says you can talk to the Justice Department about criminal and civil enforcement matters. But here's how we're going to structure those conversations. So rather than having the default be, we're not going to do that and here's the structure, it is explicit, the point that I just said, which is that there isn't a legal prohibition, you can, but here's how we're going to structure it. So I thought that was actually quite notable.
Yeah, and I'll just add to that. So, you know, I think the very early days, there was a lot of focus on the firings of certain individuals inside the department, which felt quite drastic. Day 1, day 2, day 3. You know, as you said, Trevor, of course, every administration has their policy priorities and they win elections and then they, you know, work to use the levers of government to advance those policy priorities, and that is how our government works. But I think the initial days of the firings of EOR judges, some of the long-standing, very senior career folks in the National Security Division and the Criminal Division, et cetera, these are folks who are really long-term experts and who have served in Republican and Democratic administrations. You know, there's been history around the Civil Rights Division and the Environment and Natural Resources Divisions getting kind of downgraded in terms of their work in certain administrations. One expected that. I expected it, having run the Civil Rights Division and seen it in the ebbs and flows. But it was pretty jarring, and I don't think we should take it for granted. And I think that former head of the National Security Division, Mary McCord, said she had never, to her memory, ever known a time where a new administration came in and literally, you know, got rid of senior career national security folks, experts who were day in and day out briefing the Attorney General and Deputy Attorney General about the threats facing the country, et cetera. And it happened then, it was waves, and it is continuing, but the FBI, and a lot of it has been covered in the news, but senior leaders in the FBI, obviously Jack Smith in the special counsel's office, and the kind of goings-on in the DC U.S. Attorney's office around the prosecutors who prosecuted the January 6th defendants, et cetera. This is, again, administrations have policy priorities, but the bleeding of experts, the reassigning just last week of prosecutors from the U.S. Attorney's Office in D.C., longtime career folks to handle misdemeanor cases, you know, it adds up into a thing that is, you're losing incredible expertise at the department, at the senior most level across issue areas. And it, you know, they created in my old office a very unusual thing called the Sanctuary Cities Task Force, where they started in early days to reassign some of these very senior section chiefs, et cetera, career folks who'd been leaders for their particular sections. And I think a little bit was to test, they were reassigning these individuals to the Sanctuary Cities Enforcement Task Force, which didn't yet exist. And running this task force out of the associate's office, and a lot of folks ended up leaving, but I do think it was a way to kind of flesh out who was part of the agenda and who was not. So just on the personnel level, because I know we'll talk about other issues, but this particular set of things that have been happening has been very, very jarring, and I think concerning given who has now left the department and the expertise they're taking with them.
I did want to add, because I agree with Vanita, and I think there's a cost to all decisions. You have the prerogative to make the decisions, but there's a potential cost to them, and losing institutional knowledge, continuity. It could impact productivity. It can impact the nature of your relationships with your, colleagues abroad and others you work with around the world to try to keep the American people safe. So there's a cost. I want to talk a little bit about the manner in which some of these things have been done, which has been quite surprising to me. You step back and say the people in the Department of Justice are public servants. Many of them are overworked and under-resourced, to be candid. I know, speaking from U.S. Attorney's Office perspective, that's how you feel. You feel if I had 20 more prosecutors and more staff, I can fight that much more crime and keep that many more people safe. So it is an analysis of that. And then the way that I think the new administration is dealing with personnel changes, I don't think it gives enough respect to the people who are making the sacrifice on a day-to-day basis. And I'll just talk about U.S. attorneys. It is completely normal for a new administration to come in and change U.S. attorneys. It's the president's prerogative to appoint people. I was appointed by President Biden. But typically, at least I've understood that there is a certain respect given to the sitting U.S. attorney. If you want that person to step down, you let them know, give the person the opportunity to resign. You don't get an email directly from the White House saying you're fired. It's just not how people are dealt with. So in watching some of these personnel changes, I do think about the loss of institutional knowledge and the impact it'll have on the work, but also think about the norms of how you treat people who are public service and servants and making sacrifices. And that's been a bit disappointing from my perspective.
Hey, Trevor, can I just add something that I think brings together both Breon's excellent point about how folks get treated, regardless of how you're exercising your prerogatives, and the public safety and national security impact that concerns me about some of what I've seen. I'll give you a very concrete example. Several weeks ago, you may have seen reports that a number of, at least a half a dozen, 6 or 7 different senior FBI officials were removed from their positions as executive assistant directors. Just to translate the bureaucraties, that means the most senior leaders in the FBI, other than the FBI director and deputy director. So think of them as kind of the leaders of the business lines, if you will, of each part of the FBI. The national security section, the criminal investigative section, the cyber threat section, the science and technology apparatus of the FBI. So these are more than a half dozen most senior leaders in the Federal Bureau of Investigation responsible for the issues I just described. I've served in senior positions in both, in national security positions in both Democratic and Republican administrations. I was the chief of staff at the FBI during the George W. Bush administration, during the end of that administration. What happened to the FBI and how it transformed in the 20 plus years since 9/11 should not be kind of undersold here. How it had to reorganize itself to focus on the terrorism challenge, the cyber challenge, the challenge of espionage here in the United States. And it reorganized itself to focus on those threats. It is the only law enforcement agency equipped to do that. Your local police departments aren't performing that function, aren't combating those threats that have escalated, frankly, in the last 20, 25 years. So by kind of kneecapping that entire level of management and expertise, I have real profound worry that that is going to translate into public safety and national security impacts across this country, because who is managing those functions? Who is setting the direction? Who is having the critical relationships with our international counterparts who we rely on to give us information and intelligence about terrorism threats abroad that are coming here, about cyber threats that are coming here. So I really think we should not underestimate the profound public safety impact on the loss of that expertise.
Thanks. So I thought we could talk about a particular case which may illustrate a number of the themes that we've been bringing up here, questions of personnel turnover, of influence of the White House or Main Justice on a U.S. Attorney's office, et cetera. So that just randomly selected case that I thought we'd go with is the still pending set of criminal charges against Mayor Adams. We know the government has filed a motion to have those charges dismissed without prejudice to their being potentially refiled later. The charges are basically a set of charges alleging public corruption of one form or another. These charges were first filed last fall, and then just in the last month, of course, the Justice Department filed this motion to dismiss. So what, if anything, is unusual about those developments?
Anyone?
I'll start, Trevor, and I'll be very clear here. I'm going to be very careful and not speak to the specifics of this case, as Trevor mentioned. It was pending an investigation, and the charges were brought during my tenure as Deputy Attorney General. So I'm going to be very careful not to comment on the specifics of the case. But I will say, and Breon alluded to this, it is absolutely appropriate for a new leadership team in a new administration to come in and get briefed and dig in on serious, sensitive, high-profile investigations. Absolutely appropriate. I would actually think if a new leadership team coming into the Justice Department wasn't getting those briefings, I would be concerned. So let's just level set. Totally appropriate to do that. To the extent that those briefings end up leaving the new leadership with questions about the sufficiency of the evidence, with questions about the legal theories being asserted, all of that also perfectly fine. In my experience, those questions, those issues are handled by talking with the case team, by talking with the career prosecutors and investigators to understand what has been done, what else might be done. Totally appropriate, and indeed, the Justice Manual, Vanita and Breon have talked about this. This is, as you might imagine, it's exactly what it sounds like. It is the manual for the Justice Department. It is literally, and by the way, it's online. You can go look at it. It is, at least for now, it is where you go and look at what are the policies, how do we exercise in the Justice Department our investigative and prosecutorial responsibilities. And in fact, that manual says, hey, U.S. Attorney's offices, Breon particularly loved this part of the Justice Manual, you've got to tell Main Justice, you've got to tell the Deputy Attorney General's office and the Attorney General's office about big steps that you're going to take in significant cases that might get attention, that might bear on the broader policies of the Justice Department. So it is appropriate for the politically accountable leadership to do that management, to understand what's going on, and to satisfy themselves that the evidence is there and the legal theories are sound. So that is appropriate. Where I think we get into real trouble, and this goes to the public confidence piece, is where you have differing and shifting rationales for positions that are taken in court or actions that are taken in court.
Trevor, I can speak to this from the perspective of the U.S. Attorney. You investigate cases, and our office prosecuted former Congressman George Santos. So we had in the last administration a very significant case. And I can tell you there are procedures in the Justice Manual that dictate how you handle those cases. Those cases appropriately are given a lot of scrutiny. Both at the public integrity section within Main Justice and at times at higher levels at the Deputy Attorney General's office, et cetera, because there's a lot of sensitivity to how these cases will impact people, elections, et cetera. And so it is typical to engage. And as Lisa said, in my experience, that engagement is typically about the facts, the evidence, the law, right? And everyone's going to kick the tires to make sure you're bringing a case that's fully justified and supported by the law and legal theories are sound, et cetera, et cetera. And so that is the backdrop of this case as well. We didn't prosecute the Southern District of New York, but that is the backdrop of this case. I think for me, in watching this as a U.S. attorney, what struck me was the rationale, Lisa alluded to this, the rationale given for the dismissal was divorced from the facts, the evidence, and the law explicitly. Now, I know that the AG Bondi has since questioned the strength of the case and things like that. That was surprising because the case has been presented to a grand jury, an indictment was returned, it's pending in front of a federal judge, trial date was set. And so the fact that they weren't talking about the strength of the evidence, which is typical, and whether certain theory should be pursued is typical, that it was focused on something other than that was very surprising.
And just to, some folks in the room are going to know, but that, and correct me if I have this wrong, but the two rationales offered publicly, and I think you're also saying it's quite unusual even to see the document that would provide this justification separate from what the government is filing in court. But the two justifications offered in the memorandum from the acting Deputy Attorney General to the U.S. Attorney's Office in the Southern District, as I understand it, were one, proceeding with the trial itself on the schedule that it was on would interfere with the mayor's ability to seek re-election, that there would be a kind of some sort of question of interference with the election. And two, that it would divert him from being able to cooperate with the Trump administration's priority around enforcing federal immigration law, something that city and local officials can't legally be required to do, con law students, commandeering, but that they could voluntarily do in certain circumstances.
Once a dean, always a dean.
Yes.
And so is it that those rationales, because they don't have to do with the facts in the law, it's unusual because they don't have to do with the facts in the law, but are those rationales themselves also unusual things to be citing to be making a decision like this?
I mean, I think the proximity to the election and argument in and of itself was problematic because the primary is 9 months away. There are very strict rules about at the department in the lead up to an election, and kind of, there's a lot of different terms for the 30 to 60 days in advance of the election.
Right.
But that rationale in and of itself seemed, I would say, for lack of a better word, a little shady in terms of the amount of time before the primary.
Not the idea of the rationale, but its applicability here.
Yeah, because the rationale is a real one. The department has to be deeply concerned about significant actions that could be taken by prosecutors that could be seen as influencing the outcomes of elections, right? That's a very legitimate and very important principle for the department. But I do think the shifting, and the issue of the second one around just it's going to distract the mayor from being able to carry out basically the president's policy prerogative. One could have many questions about that, and Daniel Sassoon did so. And I think that exchange of letters, I would, urge you to, and just as a shameless plug, but Lisa and I will be teaching a class about the Department of Justice in the fall, which I hope many of you will sign up for. But when we were kind of thinking about those letters, we were like, this exchange of letters is, we could do 3 classes just on this exchange of letters. And, it's within, I think, Mayor Adams' counsel sends a letter to Maine Justice on February 3rd. Daniel Sassoon responds.
The acting U.S. attorney.
The acting U.S. attorney. And then the acting Emile Beauvais, he was PADAG and the acting DAG, then sends a letter to Daniel Sassoon a couple of days later. But Daniel Sassoon's letter back, I think, really does pronounce a lot of the principles that guide prosecutorial decision-making. A very, very well-written letter that really gets to the heart of how the department thinks about, how we balance these different prerogatives. And then, the rest of you have been following, the rest of it has been in the news, but on February 14th, the department then files a motion to dismiss. And I do think what's interesting here, and there's a lot more to dig into, but is that Judge Ho, has now appointed Paul Clement to serve as amicus curiae to basically provide adversarial testing to the government's position that the case should be dismissed. And it is something the Supreme Court has done, the Second Circuit has done periodically when the government has either taken the position of its adversary in court, so the judge does not have that advantage and will appoint, and Paul Clement himself has been appointed before around the constitutionality of the Consumer Financial Protection Bureau. But I do think part of this is a record for history, to basically really dig in on a fact-finding about what exactly has transpired and whether it is appropriate or not. And the judge felt like he needed to have these arguments before him in the record before opining on whatever he will opine on soon.
And Trevor, just on the second rationale about supporting the
Immigration
agenda of
enforcement.
immigration enforcement, the one thing I worry about is sort of putting my former U.S. attorney hat on is like, where's the line with that rationale? And I think about it because we prosecuted someone who was a congressperson, and you say, well, could one president of any party decide, it would be better for my agenda to have this congressperson sitting in Congress because the majority is so slim, I need that vote. So U.S. Attorney's Office, Eastern District, dropped that case against a Democrat or Republican because we need that person to do a thing that's going to help me as president advance the agenda. So when I hear that and I looked at that rationale, I thought about, well, where's the line? What's the policy position of the department in terms of what is inbounds and out of bounds in terms of the rationale for dismissing a case, again, that is set for trial, that has already been indicted. So that is something for folks to think about.
And dismissal, just to emphasize, without prejudice,
Which
is the thing that keeps the sword of Damocles hanging precisely where it is. The implication being that a mayor who enthusiastically cooperates in enforcing and helping the federal government enforce a federal immigration law is a mayor who's less likely to see those charges refiled. And a mayor who doesn't cooperate to the satisfaction of the administration might see those charges filed again. Now, as I understand it, Bove, the acting Deputy Attorney General, saw this question and dropped a footnote, I think, in one of these communications, making clear that this is not a quid pro quo. And I will just say for myself, sometimes when you have to drop that footnote, you might rethink the posture of the whole arrangement.
And the judge actually, one of the questions he's asking Paul Clement to engage is exactly this question, which is the appropriateness of the dismissal without prejudice, right? So that's going to be a subject of the upcoming report.
I think it's, now we'll see the briefs. The briefs are due by the 7th, by the end of this week. There'll be, at least according to the schedule, Judge Ho set oral argument on the 14th, I believe. So lots to come here, but it's worth underscoring a point that Breon made, which is this is the subject, as all criminal indictments are, not of the whim of a prosecutor or a set of prosecutors, but it was an indictment rendered by a grand jury. That's 16 people sitting in a room who heard evidence, right? Now, I know everyone talks about you can indict a ham sandwich, and that's the, but having been before many, many grand juries, people take their job seriously, and what that means is investigators and prosecutors went in and presented evidence to a grand jury, explained the law to those citizens, and then they voted on an indictment. So to dismiss that and to wipe out that work is historically the government gets a lot of deference from judges on their decision, their determination to dismiss a case. But the standard the judge will apply here, what the judge has to find is that this dismissal is not clearly against the public interest, right? So he will be evaluating whether or not to dismiss this, to give that traditional deference to the government here, would not in and of itself act against the public interest.
And just for those of you who might have been watching on the live stream or seen the photos, it was quite stark for any of us who've been in the department to see the acting deputy attorney general sitting alone at counsel table making this argument. And I want to get at the reason why I want to point this out is, you know, the mass resignation of career prosecutors at the Southern District of New York is not a thing that happens every day, as you all know. And they are the ones who built the case. They investigated the case. They worked with the agents. They've been working on this case for as long as they have. But there was a very intense, and the media covered it, so this is in the public record, discussion about who would actually sign the motion to dismiss, because nobody at SDNY would, and there was a public exchange of letters, et cetera. And you can see that all play out in the context of Mayor Adams' situation, and we're also seeing in Washington, D.C., a different type of thing playing out where a U.S. attorney or acting U.S. attorney is asking career prosecutors to open investigations that career prosecutors don't believe there is a predicate for, and then the career prosecutor resigned. And so this push around, you know, the kind of expertise of career prosecutors and being commandeered for political reasons, improper reasons, or at least reasons that the career prosecutors believe is improper, is something that we are seeing play out very much in real time, and a dimension to this which most people in the American public may not understand or care that much about, but is actually quite distressing for those of us who know how the department works.
There's a small detail. I wonder if any of you have any thoughts on it. The reporting, at least, is that after no one in the Southern District would sign the dismissal motion, that the acting Deputy Attorney General sort of went to the Public Integrity section of Main Justice. A number of those lawyers resigned, but put the remaining ones in a either literal or virtual room and said, you know, you've got an hour for one of you to agree to sign this paper or you're all fired. I don't know whether that reporting is true, but it is the case that one person did ultimately agree to sign. The reporting suggests to save the jobs of his colleagues. Having gone through all of that trouble, it then struck me as odd that the acting Deputy Attorney General appeared alone for the hearing. He's admitted in the Southern District he could have been the one alone to sign the dismissal motion, and yet he seems to have engaged in some level of persuasion bordering on coercion to find someone else at Main Justice to sign the motion. Why do you think that happened?
I'd love to hear Breon's comments on having an acting Deputy Attorney General appear in the district. Just for the record, I never appeared at counsel table during my time as Deputy Attorney General, nor did I appear without the U.S. Attorney when I went to the district. But
no, I think it's odd, right, to see that, and I speak from position of U.S. Attorney, it's like you feel like this is your district, your courthouse, these are your judges. So if there's something that's going to happen in a case that you indicted, you or your people are going to stand up. I think the situation we saw was that no one in the Southern District, and frankly Penn, thought they in good faith could make the arguments that Mr. Bove thought needed to be made in support of this motion to dismiss, and he probably felt if these arguments are going to be made and made in the way I want them to make them, I got to show up and do it because nobody's going to do it justice. That's how I interpreted it. The getting someone to sign, you find somebody to sign, typically the DAG doesn't sign briefs and papers. It's done by folks on the team, and Penn is involved, Southern District is involved. But I think when it came down to facing Judge Ho and understanding, you remember, all this information was in the public stream about how the Southern District acting U.S. attorney felt, how the prosecutors on the team felt. All this stuff was in the air, so you have to go up in front of the judge and be able to deal with anything the judge may throw at you, so he probably thought he was the best position to do it.
I will again commend the letter and the memo that Danielle Sassoon wrote on this point. She talks about the unique responsibility of a federal prosecutor And those of us who've been privileged to be federal prosecutors understand what this means. Your duty is not to win cases, it is to do justice, to present your case, warts and all, and above all, to adhere to your duty of candor to the court. And what she writes about in this memo is her view of that duty and her belief that she couldn't make the arguments that were being asked of her. So it is a really well-done description about the role of, and the unique role of a federal prosecutor and the responsibilities that adhere to a federal prosecutor that are different from other advocates that appear in court.
Trevor, I just want to make
Please,
one
yeah,
point, because Vanita brought up the acting U.S. attorney in D.C. One thing that, and you all hear me say I worry about a lot of things, but one thing I worry about is sort of the public confidence, the public perspective that the Department of Justice is now, applying one set of rules for certain people and another set of rules for another. I was struck because he made comments, and I think it was on social media, about threats toward Doge workers, right? And how he was going to take strong action against those. Now, we've prosecuted threats cases, and I think anyone who violates the federal law and threatening public workers and federal employees, if there's a federal case to be made, should be made. I think that across the board. What I thought is interesting is sort of the same way one is worried about and takes seriously threats against Doge workers, there's a different view of threats against members of Congress and the former vice president just a few months ago. And you can't have a system of justice where I'm going to enforce the law when it comes to my tribe, but when it comes to the other tribe, not so much. That's just not how the law works. When we say equal justice under the law, it's that. It's not about your political affiliation, your wealth, your stature, who you're connected to. It's about the evidence, it's about the law, it's about justice. And I worry that as the public watches these things happening, the confidence in the ability of the Department of Justice to do justice and pursue equal justice under the law is going to be severely shaken. And I worry about that.
We're going to open it up to questions from all of you in a moment, and I'll ask you to come up to one of these two microphones if you have a question to pose. But just one last, sort of shifting gears a little bit, just to look to the future, now not focusing on any particular case. But one of the other distinctive things about the first month and a half of this new administration, of course, is the volume of executive orders that the president has signed, articulating some quite dramatic changes in policy and posture of this administration, a range of topics, especially in contrast to the Biden administration, but in some instances in sharp contrast to the previous 6 or 7 administrations, revoking executive orders dating back to the Johnson administration, for example. On some of these executive orders, the subject matter has immediate implications for the work of the Justice Department. There's an EO that I think, for at least by my lights, has been underreported upon dealing with capital punishment. It's not unusual for a new administration to articulate a position on capital punishment, on when it's appropriate to seek the death penalty in federal criminal cases that might be a departure from the position of prior administrations. This EO has some unusual features, though. It directs the Attorney General to take all appropriate action to seek the overruling of all Supreme Court precedents that limit the authority of the state and federal governments to impose capital punishment. Like all precedents that limit the authority, so like Gideon, Miranda, I don't know how far that's supposed to go. It also directs the Attorney General to evaluate the conditions of confinement for each of the people whose death sentences had been commuted by President Biden, and to take all lawful and appropriate action to ensure that those offenders are imprisoned in conditions consistent with the monstrosity of their crimes. That's something you don't read every day in an executive order. Whether it's these areas or others, DEI obviously is an area where the administration has been very active. Are there areas that, based on how the administration has articulated its policy priorities, that we should expect will be reflected in priorities for the Department of Justice over the coming, say, year or 2 years? Where do we think it will be focusing, this department, in its investigative work, prosecutorial work, civil, criminal, wherever you'd like to focus?
Well, I think you're already seeing it, right? The acting Deputy Attorney General issued a memorandum. And again, I want to underscore it, not unusual at all for a new leadership team to come in and reverse, withdraw, change policy priorities, change guidance to prosecutors about how they should approach charging and sentencing decisions. That was done in 2021. The then acting Deputy Attorney General and then acting Attorney General came in and withdrew what had been a guidance to prosecutors about charging and sentencing that had been issued by then Attorney General Sessions, and replaced it with a different set of guidance. It's all, that is quite in the main kind of regular order. But what you've seen now, in addition to that, kind of a new issuance of charging and sentencing guidance to prosecutors that actually reverts back to that 2017 guidance that I just mentioned, you've seen an articulation of priorities within the Justice Department about immigration enforcement, to the point of directing FBI agents from joint terrorism task forces to divert resources from those joint terrorism task forces to immigration enforcement, to drug cartel enforcement, and prioritizing the fentanyl epidemic and crisis. So all of that, I think, is where we should expect to see continued activity. You've now also seen the disbanding of investigative task forces and work on foreign malign influence, on Foreign Agents Registration Act enforcement. So you're seeing a quite clear erasure or downgrading of those priorities.
While it is certainly true that every administration is going to come in with their own positions on the death penalty, administrations don't get to decide what conditions of confinement a particular person is experiencing based on who they are and what they think of this particular person in prison. And we have a constitution, and thankfully these individuals are represented by counsel, and inevitably, if there were truly, and I don't know, I mean, some of these EOs are messaging executive orders that were never run by the Office of Legal Counsel very clearly, which has the task typically of reviewing all of these executive orders. I don't know whether this one is a messaging one or not, but presumably there would be a lot of litigation where there are efforts to kind of place certain people in particular conditions of confinement that didn't have anything to do with safety and humane treatment. So on that one, I will say that about that, as unusual as that is. On the DEI one, there's a lot of ongoing litigation. I expect more about whether it's actually legal, whether violations of the First Amendment, et cetera, and there's a lot of things about the legal theories that are being brought to challenge. But I think what fundamentally—
With big potential implications for universities.
With huge implications for universities. And the thing that I think is important here to talk about, and this goes to the DEI EO, it's also to the memo that the Attorney General issued to say we're going to go after, investigate state and local elected officials who refuse to kind of, go with our immigration prerogatives and commands, is the chilling effect that it is having on institutions all over the country, universities being among the top. And the Civil Rights Division is now housing a task force that has listed 10 particular universities that they will be visiting and investigating with other agencies across the federal government.
Including this university is on that list.
Including New York University. And doing a top-to-bottom review of, DEI policies, et cetera. And the chilling effect is profound. And we were talking about this a little bit, Trevor, but institutions that are going to overread while litigation is pending, walking back kind of things that are core to the existence of the institution and its student body, et cetera, to me is in some ways even more concerning than the executive orders themselves, and also the kind of dehumanizing language they use to make women and people of color feel like the only reasons they ever got any job is because, you know, they were a DEI hire, et cetera. The cultural implications, the kind of psychological implications for this country are profound, but the chilling effect on institutions is really deeply concerning. And it has bled not only into how universities need to now think about what they're doing, but the law firm community. And we saw the kind of memo, the letter that went to Covington and Burling last week, because they have represented Jack Smith, the kind of threats being levied on the legal community. And many of you will be going to law firms this summer, but there is a chilling effect even on law firms from speaking out and who they're representing, which is such an anathema to what our legal institutions and what it means to be a lawyer representing unpopular and popular clients alike. So this part of how this all seeps into our institutions, our universities, our people's views of themselves, the legal community, I think are the much harder things that 4 years from now, 6 years from now, 8 years from now, we will still be confronting, because who walked back things that may not have been illegal? And what did that mean for the student body? What did that mean for professors that were trying to teach constitutional law in this moment? And so that's the stuff that we can't know just yet. We're 6 weeks in, lots of litigation afoot, but those are the long-term effects that I am deeply concerned about.
Trevor, can I say one thing? Benita just said it, I was thinking, it's only been 6 weeks. It feels like it's been 6 months or longer.
6 years.
I will say, with respect to criminal enforcement priorities, they can and likely will evolve, because events dictate often policy choices. So if you have a Madoff occur, for example, massive fraud or an act of terrorism that calls for more resources to be surged in a certain place, that will likely happen. So you have a lot of different things that can influence where the criminal resources are going to be focused, and that's driven in part by what's happening on the ground. So we shall see.
But to the point that Benita just made, the relationships, the chilling effect also happens with our law enforcement partners.
Yep.
So if you're diverting members of the Joint Terrorism Task Force from focusing on terrorism threats to engage in immigration enforcement. Not that immigration enforcement isn't important, but you've got literally tens of thousands of agents at the Department of Homeland Security whose job that is. It is uniquely the function of the FBI working with their state and local law enforcement partners to address terrorism threats. So if you're diverting those agents to immigration enforcement, who's watching the terrorism threats, right? If you are threatening to open investigations into state and local partners because they haven't been sufficiently cooperative on immigration enforcement, are they going to be willing to work with you to go after violent crime? The work that the federal government and federal law enforcement does on violent crime is entirely by, with, and through its state and local law enforcement partners. You have to have those relationships of trust and cooperation. If the federal government is in an adversarial posture to our state and local law enforcement partners, I worry about the implications for public safety of that posture.
We have a little time remaining for questions, and I suspect there are many here. Why don't you start us off?
Absolutely. Hi, everybody. My name is Dennis McGrath. I'm a 1L here. So thank you all, first and foremost, for being here. It's a really enlightening conversation. And I actually had a question, Professor Gupta, about one of the points that you just brought up about the longer-term impacts of the change in the direction of the Justice Department. I think one of the most effective strategies used by this administration is kind of generating outrage for everything that they do and sort of distracting people from what maybe the longer term effects might be. And so I'm just very curious as to how you distinguish between some of the shorter term impacts that can be erased by a new administration by like rehiring people, changing policies, that sort of thing, versus the more longer term effects such as undermining trust in the Justice Department itself in the long run.
Yeah, it's a great question, and I'm not sure I have the answer. I think that, the kind of efforts to, I think, dismantle the federal government writ large are something that are quite unprecedented, and the Justice Department is a part of that effort. And then I think there are very unique sets of dynamics that we talked about up here that have to do with, who is seen as having been against the president, et cetera, that are unique to the department. But look, again, I think we would distinguish it as every president has policy prerogatives, and we understand that, and that is the way our government works. But the undermining of norms and the breaking down and firing of experts who were there, who are supposed to be nonpartisan actors, apolitical actors, and that type of thing, and then the kind of longer term, undermining of confidence in our institutions. I think we have to acknowledge that there is all-time low confidence in the public, and it doesn't have anything to do, it pre-existed this administration in our institutions in government. And that is a thing that we have to confront and contend with, I think, for the health of our country longer term. And that is work that a lot of us are currently engaged in at this moment, because I think the consequences for our democracy are quite profound. How we talk about it, we haven't maybe been effective at that, et cetera. But there's differences between policy actions that can lend itself to substantive litigation challenges. They're playing themselves out in court, et cetera, whether it's illegal, whether it's legal, et cetera. But it's the other things, the breakdown of infrastructure, the breakdowns of these norms, the undermining of public confidence, that I think is not amenable to litigation per se, but is truly about who is standing up for these, norms and values, who is being harmed, and how are we presenting those harms to the American public so they can see that in real ways and understand it. This is a great topic of conversation that I think really needs a much longer conversation, but I do think we have to distinguish for all the reasons you mentioned.
Hi. So you spoke a little bit about the impact of the loss of the highest levels, like career public servants, and notably like the institutional loss, but the other piece is kind of the lowest level, and like the hiring freeze and the blocking of young lawyers and legal interns from joining the Justice Department, including unpaid interns. So can you speak to that impact?
Yeah, look, one of the things that I was most disturbed about is hearing that all of the honors program offers had been canceled, the disbanding of the Presidential Management Fellow Program. That is a wonderful, wonderful program to bring non-lawyer expertise, management, which government could definitely use more expertise in that. So the disincentive, erasing those orders and those offers rather, and the upending that's doing to so many people's plans and careers, that's obviously concerning in the short term. In the long term, the disincentivizing and the kind of denigration of the civil service I really worry about the long-term implications there. Who is going to be willing to devote their lives to public service if we are going to be in a cycle of every 4 years, it just gets upended, right? Folks should remember just giving the Justice Department as an example, 115,000 people work in the Justice Department. The entirety of political appointees across the entire government, Senate confirmed and non-Senate confirmed. Anyone want to hazard a guess? I'll short circuit, 4,000, okay? So just doing the math, the number of political appointees in the Justice Department of that 115,000 is infinitesimal, right? We rely on people willing to serve and devote their lives to public service and to build up that expertise. So if we lose that, it's going to have profound implications.
Yeah, I agree. It's a huge recruiting challenge that the department will have to deal with for many, many years to come. Also think it's a morale hit for the people who actually work in the department now, and that's something I think the DOJ needs to be mindful of.
These really, I think, are connected. The erosion of the norms that have been the basis upon which the Justice Department and other institutions in our government have earned and maintained trust is connected to the then loss of personnel, whether it's intentional on the part of the administration through hiring freezes, or as has been pointed out, just at some point soon, there will be a supply problem because people who would have been inclined to devote at least a part of their careers to public service will think otherwise. And then even if the administration 4 years from now is very differently minded on all of these fronts, I don't think it will be straightforward to sort of rehire people who had spent decades.
Look,
I think they'll be unavailable and that expertise will be lost.
it's a hollowing out
Right.
of our agencies, including the department. And I don't think that the supply problem is one that DOJ cares about. In fact, it's not a problem.
Right.
And so the civil service has built in a lot of different protections against some of the actions that have been taken, and certainly, but it is not easy to hire back, as we all know, or as Lisa and I know, and even Breon, and so this hollowing out is going to have much longer term consequences, not only on the kind of people, experts in federal government willing to engage in that public service, but I think also in public confidence in these institutions.
And on the public, I mean, there are things that you won't be able to do. You have fewer people to do them.
Benefits,
it's a practical,
programs, absolutely.
Impact.
It's a hard thing to translate to the public, I think, or it can be hard. Part of the sort of DOJ effort, I think, to people who aren't familiar with government, aren't sort of just don't know about how the civil service operates. It just sounds like we're looking for waste and fraud or just inefficiency in the government and trying to root that out. And no one would contend that government is free from inefficiency and waste.
Right.
There's plenty to fix there. And so I think it's a bit of a communications challenge in this moment for the public to understand what's at stake with this hollowing out of the civil service.
I think that is something that really does concern me, because I don't think any of us sitting up here would say government doesn't need reform, or there aren't places where the deep inefficiencies of the bureaucracy, et cetera, we wouldn't have loved to have gotten our arms around, or that it doesn't. But it is hard to make people care. We're talking about the Justice Department, but one thing I don't know is how many people outside of Washington, D.C. and law schools care about what's truly happening at DOJ, and how do you make people understand what's at stake on these broader, you talk about the rule of law and democracy, and apparently we didn't really know how to talk about that in ways that felt real for people in their homes when they're dealing with not being able to get groceries within their budget and stuff. So this is a big quandary, I think, for those of us in the legal community and in the media as a comms piece, to make people understand why this matters to who we are as a country.
Well, that is not a cheery note to end on, but it is where we will end. Will you all join me in thanking our terrific panelists today?
We hope you enjoyed the discussion. You can find all of Just Security's coverage of the Justice Department and the Trump administration on our website. If you enjoyed this episode, please give us a 5-star rating on Apple Podcasts or wherever you listen.